Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV150329, Stevenson versus Harmon. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and your client. Each side has 20 minutes for argument, and counsel for the appellant is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we have conferenced the case prior to argument. So with those preliminaries, is it Mr. Vangelli? You may proceed. Thank you.
Good morning. I am John Vangelli. I represent the plaintiff appellant in this matter, Howard Stevenson. Thank you for the opportunity to address the court on these matters and give some oral argument. As set forth in the briefs, the summary judgment standard is very clear. Summary judgment can only be granted if there are no conflicting issues of fact and no reasonable inferences that can be drawn, differing inferences that can be drawn. It is the appellant's position that this case was improperly taken away from the jury because there are multiple issues of fact, and the judge at the trial court level did not appreciate that, and that I think is evidenced by the transcript of the oral argument. The judge gave multiple hypothetical examples on other situations that might apply or take something into or out of the fireman's rule. And just by the fact that there was such a spirited debate with all these different hypotheticals, that illustrates that reasonable minds can differ on the facts of this particular case. What the judge seemed to do at the trial court level is he put in what I believe he referred to as a sliding scale. When does an emergency go from a routine matter to an emergency? And from my research on the matter, it does not seem like that's really an element to be set forth in the cases either in Arizona or the cases we refer to in other jurisdictions.
Well, let me interrupt you because,
yes.
As you know, we will affirm if the Superior Court was correct for any reason, even if we don't agree with its implicit reasoning. And
yes, Your Honor.
I'm not inclined to parse this incident based on a minute-by-minute analysis of, was it an emergency at the outset, did it become an emergency? But looking at, for example, your complaint, I want to ask you whether, as a matter of law, a court could conclude that this was an emergency within the meaning of the firefighter's rule, because in your complaint, which to some extent your client tries to downplay, well, not to some extent in his affidavit, but you say that he was called regarding an open gate and a menacing dog roaming the front yard. You saw punitive damages due to the risk to human life that the Harmons caused. I'm having a hard time squaring your own client's allegations with the notion that this was anything but an emergency.
Yes, Your Honor. And I appreciate the question. That's a very good question.
Thank you.
The complaint is allegations. It's exactly that. It's something that the plaintiff is intending to prove or feels they have that evidence to prove at that time. As we know, the disclosure process is not static. Sometimes cases, you discover facts that make cases better. Sometimes you learn facts that make cases worse. So those are allegations that the plaintiff is making.
Complaint, I mean, yeah, that might be fine if it were, someone saying, well, gee, when we looked at the answer, there were further things to be discovered, but it was your client's complaint.
Correct.
So you weren't going to take discovery about your client's complaint. You knew what the client knew, the complaint reflected what the client already knew. Mm-hmm. And there are some cases that say the complaint can be sort of like a judicial estoppel. You're bound by what you say in your complaint. So why isn't that, getting back to Judge Downey's good question, why wasn't that, I mean, the menacing, unleashed and unrestrained, a menacing dog roaming the front yard, when your client was there on the sidewalk, the dog attacked him. Why isn't that an emergency?
Well, I would answer that in two ways. One, again, the complaint is allegations. I didn't get a chance to anticipate that question and look at the answer to see if those allegations were denied, assuming they were. That's a question of fact right there, and that would be a plaintiff's burden to.
But you can't rely on the complaint. I mean, they could deny certain things and admit others.
Sure. And I didn't get a chance to look at that in anticipation of this
What are the
oral
facts?
argument.
What are the facts that you think disprove those allegations in the complaint?
Well, again, once you get into the discovery on the matter, discovery, you learn stuff, as I was saying, that may help your case, that may hurt your case. So when we get into the facts of the matter, and Sergeant Stevenson had an opportunity to give his deposition and then prepare his affidavit, and I would offer that the affidavit filled in gaps that were not asked of him in his deposition. I don't even think the deposition was actually referred to in any of the below court proceedings. So he filled in his affidavit to give his factual accounting of what happened, and he's prepared to testify about that. So he's
What are
saying,
the strongest facts in your view in the affidavit that contradict the notion that it's a menacing situation that's an emergency?
if you give me an opportunity to get there, Your Honor, just a moment.
And when you're looking at that, let's exclude, if you can, exclude the portions of the affidavit that's just conclusory.
Fair enough, Your Honor. Sergeant Stevenson shed light on the documents that were the call-out documents. So he explained what a priority 2 call is. I think that's the first question of fact. An emergent call would be a priority 1. This is a category 2, and I've set forth the other elements listed under a priority 2 call, and some of them are not emergent at all.
But that doesn't change whether there was a menacing dog in an open yard. It's just how it's categorized. It seems like the facts are still there.
Okay.
And before you move on, as to a priority 2, that would include a motor vehicle accident with injury, which is what we had in Reed, and we applied the firefighter rule there.
Yes. It also includes, issues of sexual conduct, no matter what time it occurred, and if the victim's in the hospital. So, I mean, if the victim's in the hospital 2 or 3 days later, there's certainly not an emergent situation there, assumedly, that an attacker would still not be able to get at the victim. So, and I think there was stolen stolen license plates, things like that. So there are clearly, it is a spectrum, but there are clearly some situations that are not emergent set forth. I would actually suggest all of them.
What you're saying is whether it's a priority 2 or not, whether it's a priority 2 includes emergency and non-emergency things. Right?
No, I think priority 2 includes no emergencies. I think there's a true emergency. It's a priority 1. That's what I believe. And again, that goes to some of the facts set forth in the affidavit where he said they were not in a hustle to get out there. The only reason why the police responded to the menacing dog is because the person who called in the order to Crime Stop, not even to 911, asked for an officer to arrive. Again, addressing the menacing dog, Sergeant Stevenson described that his training is not to try to contain a dog, but to call animal control, and that's what he did. So that puts the case in more of a posture of a routine matter. He's at a scene. He's not rescuing anybody. He's not there for an emergent reason. He's standing by,
It
waiting.
seems like a routine matter. It's something that you could do any time.
Like opening an electrical box to check on the breakers.
Sure. And again, as Sergeant Stevenson pointed out, he was not in a rush to get to the call. And if there was another call that came in that took priority, they would have taken that. He set forth that in his affidavit as well.
So the Phoenix Police Department document that the defendants attached to their motion for summary judgment statement of facts says priority 2 calls will be incidents that are urgent in nature, where a potential for violence may be present, a timely response is necessary, and the incident is non-life threatening. What, if anything, do we make of that?
Again, Your Honor, I think that's a matter of interpretation, and I think a jury could interpret that differently.
A routine urgent in nature is vague.
Well, I think, again, let me go ahead and get to the actual document, Your Honor.
And it also talks about whether the call comes in on a 911 line or the Crime Stop line.
Yes.
These same terms apply.
And you might also recall, while I'm looking for this, that there was a discussion with the trial judge about 911, and the trial judge actually made the point that lots of people misuse the 911 system. So the fact that a call is made to 911 or a Crime Stop can't really be determining, and I think that creates an issue of fact on what the nature of the call when received. And that being said, that's why Sergeant Stevenson interpreted in his education training experience as a sergeant, a long-standing sergeant with the Phoenix Police Department, what these calls actually mean. And again, that was not inquired of him before the affidavit. So on the list of priority 2 calls, we also see theft of a license plate, domestic violence where no physical abuse is occurring. So that almost sounds like an argument. A verbal dispute, audible alarms, which I think is one of our cases as well, where an officer was responding to a burglar alarm. That was set forth in one of the footnotes to our opening brief.
I'm more focused on that 4A language. Priority 2 calls will be incidents that are urgent in nature.
And again, there was a discussion with the trial court on urgent versus emergent, and the trial judge made the determination, you go to urgent care if you have a cold, you go to emergency care if you're having a heart attack. And again, I do believe that's a question of fact. I don't think that's something the trial judge could take away from a jury.
Is it a fair reading of the affidavit in light of the complaint that essentially what they were faced with was an aggressive dog in an unfenced yard or where there was a gate open that was menacing or scaring people as they walked by? Isn't that a fair reading? I mean, at least that's the way I read, interpreting the affidavit in the light most favorable to your client.
Yes, Your Honor.
That's the way I read that in light of the complaint, to harmonize them. That in essence, he was called out. Who knows what he's going to find when he gets there? When he gets there, there's a dog not in an enclosure, so he's not in a leash, not in a true enclosure, that is menacing people as they walk by. He goes up, he's on the sidewalk, waiting for animal control to come, and the dog attacks him. Is that a fair summary of what the facts were?
That's fair, Your Honor. And I would add one thing to that, and I know I took Judge Downey's thoughts of not wanting to parse out, minute by minute, but again, when a call comes in, that dog could be acting differently than when the sergeant arrives. And as the trial judge said, the situation can change, and I haven't seen that in any of the case law, but it can change again from non-emergent to emergent. So the dog could be acting one way when he arrives there, and they decide to set up a perimeter and just watch the dog and make sure nothing escalates from that, which I consider as routine.
But when they get without parsing it out between time.
Yes.
Who knows what the call is? I mean, if someone calls and says, gee, I've called 911.
Sure.
And said I think someone's trying to break into my house.
Sure.
It was a raccoon.
Okay.
That was throwing stuff in. But, that may be an emergency.
That's fortunate.
It probably was an emergency. Luckily, the raccoon did not attack them.
Well, I think
But so we don't know. My point is, we don't know, Rocky. We don't know from just the call itself. But a fair reading of the affidavit is that he gets there, and it is a menacing dog in a non-enclosed yard that people were scared, and he just sort of is watching it, waiting for animal control, and the dog obviously is able to jump out of the yard because it attacks him on the sidewalk. That's a fair statement of what he was faced, right?
Well, again, I think we might be adding some facts there, Judge. I don't recall anybody being scared. I mean, if you see a dog coming out, you could not be scared and say, hey, the neighbor's dog is out.
There's a call that said there's someone menacing.
Crime Stop, and then, of course, Sergeant Stevenson addressed in his affidavit when he arrived on scene, the caller was not frantic.
Right, except that the caller was by her car.
I'm sorry?
We don't know where the car was, but the caller wasn't petting the dog.
Sure. That's a fair assumption.
By her car, I'm saying, well, yeah, the dog's going to. Maybe the car door was open and she was sitting there waiting to see what happened.
And Your Honor, I think you illustrate another good question of fact that should have been determined by the jury, and that is the call out per the records was for an open gate call. And again, we used menacing in our complaint. It seems like everybody's fixated on that word. Again, I'm suggesting that's an allegation we made that did not come out in discovery. It was in the complaint. So
not just that you said it was menacing. You said that the Harmons, by letting their dog be unleashed, consciously disregarded the substantial risk that seriously. Is that the correct spelling of that dog's name?
Yes, Your Honor.
It's not
I think it's
Sirius, which is a more.
Serious. I think it's a star, if I remember. So when I looked it up, I think it was a star is what he was named after.
Okay. But you say that the Harmons consciously disregarded the substantial risk that Sirius would cause serious injury to pedestrians like Sergeant Stevenson. So I'm just having trouble with this whole concept of it seems like based on your own client's allegations, this was a situation that involved a substantial risk of serious injury.
Your Honor, what you're reading from is the punitive damages portion. And as I've had many cases I've been doing.
Actually not.
Was that not the punitive? Well, that's, I can recognize that as the punitive damages language,
Well, it's under your-
let's say.
What does it matter?
It matters
It's
because.
still an allegation that there was.
It's an allegation.
There's an allegation of fact, right?
What I was going to say is I see often in doing personal injury for a while now where you allege punitive damages, maybe the judge allows it, maybe it doesn't, maybe the facts do not pan out where it supports a punitive damages claim, and then you withdraw the
allege those
allegation.
facts.
I'm sorry?
The issue is you allege those facts.
Correct, subject to discovery
Those
and
circumstances,
withdrawal. I've
Really
withdrawn
not
punitive
a-
damages
I mean,
claim.
you can't just say it's an open gate case. I mean, there's no reason to call the police if just a gate is open, absent some, presumably, as here, there's a concern that a dog's going to get out. People leave their gates open all the time. I'm
Sure.
guessing without a call to the police. So and the fact that your client gets there and doesn't immediately do something doesn't change the fact that there's a dangerous condition there. He stays. He doesn't just go home and say we can address this anytime we
Sure.
want. Obviously,
I
he
agree with
stays
that.
until the
And-
situation can be addressed.
And I think that goes more to the issue of if he's there in the course and scope of his duties. And I think that's established. I think nobody's disputing that he was there in the course and scope of his duties. The issue is whether or not it's an emergency. And I think that's the primary fact that the jury needed to determine.
But if he's there because he's waiting for animal control, doesn't take out his weapon and shoot the dog. He's waiting for animal control, but he's there. He's not walking away saying, oh, I saw a nice little poodle in the yard, and it's not messing anybody. I can just forget the open gate. The gate is open.
Sure.
There is a risk involved. There's a risk of danger here.
Wouldn't there be a risk in investigating a fuse box or walking on a staircase that would potentially collapse? I mean, again, I think we're kind of getting into the sliding scale.
Well, but here, when you do a fuse box, it's, I'm just inspecting a fuse box. It was like, then it's not the cause, the fuse box isn't the cause of my injury. It's the fire. Okay, here, they're one and the same. The reason that he's there is the dog in an ungated yard, and the reason he gets injured is the dog that was in an ungated yard.
Again, Your Honor, I disagree. The call-out was for an open gate, and this goes to the footnote we had in one of our briefs that there was a case I actually found a little bit later, and that exact situation was a call-out to a burglar alarm. When the two police officers responding jumped the fence, they were attacked by a dog, and the court found the reason they were there was a burglar alarm, which may or may not be an emergency. As we saw, alarms are Category 2 in the Phoenix policies, and then the dog biting him was found to be a separate issue. So I think that's again, I think that's a good illustration that these are questions of fact that reasonable minds could differ on.
Are you saying there was a question about whether your client knew that there was a dog, that it was an open gate with a dog, a menacing dog?
No, Your Honor. What I'm saying is that the call-out was for an open gate. What if he arrived there and the dog was long gone? It's a very different situation. Does that make it any less of an emergency that if he's there making sure the dog, his intention was to follow the dog. His intention was not to contain, as he set forth in his affidavit. He was not going to contain or try to capture the dog. He was going to leave that for folks with the specialized training in that. And with that, I do have 2 minutes and 45 seconds, so I'll reserve a couple minutes for rebuttal. Thank you, Your Honors.
Thank you. And Mr. Manhart.
Thank you, Your Honors. Darrell Manhart appearing for John and Barbara Harmon. The public policy that the cases talk about is to, is that the tort system is not the appropriate vehicle for compensating public safety employees who are injured by virtue of risks for which they're paid to handle as part of their job. And that's what this situation was. Mr. Vignelli is advocating a dilution of the rule to make it basically unworkable. We have a policy that the Espinoza court says is supposed to operate as a complete bar to recovery. I recognize that the cases talk about narrow construction, but still you need to have a rule that people can recognize when it applies and when it doesn't.
Can you envision circumstances that would be a gray area that would need to go to the jury on this sort of threshold issue of emergency versus non-emergency?
Not off the top of my head, Your Honor. The question as it's presented in the earliest case, Grable talks about this as a question whether there's a duty owed to the public safety officer.
The case law really has evolved, and one of the things I think I disagree with you about is this notion that, well, the emergency requirement doesn't really exist. I think it does. I think Reed versus Kiefhofer put that notion to rest. And I think when Espinoza adopted the firefighter's rule, Justice Birch noted that one of the limitations on recovery was its application to emergency situations, and that comports with tort recovery principles. So I think I disagree with you on that point. And so I'm not convinced that there couldn't be a gray area. I don't know that this is that case.
Well, Your Honor, to debate you some on that, if I'd like to compare maybe Orth and Reed to some extent. Orth is the one that the plaintiffs rely upon the most. They want to say this is like the routine inspection in Orth and not like a Reed or White case. And in Orth, what you have, of course, is the fire department employee showing up for what's called a routine inspection. And rather than routine, I would suggest phrasing it more in terms of, is the a rhetorical question, so to speak, is the officer there for something for which no risk, danger, or hazard is to be expected, like a routine inspection in Orth, or is the officer being present for which there may be some risk, danger, or hazard? The potential
There's a risk,
exists.
danger, or hazard to me, that's a more muddy standard that would go to the jury more readily than what we have here. I'm not sure how that would help.
Well, Reed talks about the question of what is the reason that compels the officer to be present on the scene.
But under that theory, any time an officer or a firefighter was on the scene as part of their duties, then the firefighter rule would apply, wouldn't it?
Well, you could argue that, and that would certainly make
Agreed.
that would,
and that's where I thought I disagreed with you in the answering brief, that you were trying to go there. And I mean, I understand that argument if we were writing on a clean slate, but I just don't think we are. I think, Reed's statement that non-emergency situations do not trigger application of the rule is pretty definitive.
well, okay, we can, maybe we're debating what's emergency, but again, if you take a look at other words, like I can't remember if it's, in fact, it's Orth talks about other jurisdictions, talks about exigent circumstances. And exigent maybe sounds like a fancier word for emergency, but I think it's actually something doesn't have to be quite the same degree. Exigent, I believe, just means some urgent situation requiring prompt or immediate attention. And we spent some time with me listening and you talking to plaintiff's counsel about the priority to call, and Your Honor quoted what the language is from their manual. It's a call that's urgent in nature. It doesn't expect life-threatening risk, but it does talk about the potential for violence. So while there's 2 pages of things that they list as examples of priority 2 calls, when the officer's called out on a priority 2 call, there is in the nature of that the potential risk. And in this particular case, if Your Honor, I'm suggesting maybe I should confine myself to these facts here. These facts here, the officer is called out on what's a menacing dog call. In fact, I'd contrast, maybe look at the items that are pre-exist and post-exist the motion for summary judgment. The complaint and the disclosure statement of plaintiff that were attached to the motion all talk about a menacing dog, a dog that's aggressive and growling. Your Honor?
Why do we, if you have even under the summary judgment standard of construing the record in the light most favorable to the non-movement, to the plaintiff in this case, you have a complaint and disclosure statement that says menacing dog, priority, and then an affidavit that says priority 2, which has urgent, with life, with danger. To me, there's nothing that defines emergency. And so if we agree that this is an emergency situation, why do we have to debate whether the firefighters' rule should be expanded to non-emergency situations or shouldn't apply to policemen? It's basically means, to me, it's a fairly simple case, isn't it?
I do agree, Your Honor, but I'm answering a brief that tries to argue more broadly. I do think this is a very simple case. It's maybe not the classic case in which the rule originates, but I do agree this is a simple case in which I think the firefighters' rule clearly applies.
And I'm not criticizing you for answering Judge Downey's good questions, but I guess what I'm saying is we don't need to go, you would agree with me that we don't need to go that far if we agree with you this is an emergency situation.
That's correct, Your Honor.
Okay.
You do not need to go that far to affirm this case.
Okay.
And I do take the position that this call out for a menacing dog is a sufficient emergency without debating any sliding scale, that the rule should apply, and nothing has been presented to show this should fall under any exception to the rule.
I am curious if a call for a a cat up in the tree,
Kitten.
a cute kitten up in the tree, would that be an emergency?
Well, when you present it with no more facts than that, Your Honor, you offer me nothing as defense counsel, I guess, to argue how that one should be an emergency.
Depends what the cat's name is. If it's Tiger, it might make a difference, right?
Just a concern that the cat's going to fall out of the tree.
Right.
Well,
Somebody's head.
if I'll pick up the challenge, Your Honor, maybe your question sounds like you're asking me in terms of the Officer Stevenson, but if it was for a different public safety officer, let's say a fireman or somebody else whose job is to get kittens out of high places, maybe there is a risk there that's recognized.
But maybe not. Don't they just open up a can of food and the cat jumps down?
I'm assuming you have to get the ladder out.
Oh, okay.
Just ignore us.
I'm sorry.
Okay, I'm sorry, Your Honor. Well, I think maybe I should just ask if there are any further questions for me. Okay. All right, thank you very much.
In rebuttal, Mr. Gonzalez?
Lawyer's last words, a few quick points. We only have two and 3/4 minutes here. Appellee's counsel addressed the policy of the system, that this is an appropriate place to have torts under these circumstances. The policy for summary judgments, as set forth in the brief, is that negligence cases typically are not a good candidate for summary judgments, on the basis that most of the time you have facts that need to be determined by a jury. I think you discussed the gray area, Your Honor, and I agree with you there. It's not clear, and I think, again, that's one of the other reasons why it does need to go to a jury. Gray cases or gray areas that cannot be addressed by the judge need to go to the jury for determination. We talked a little bit about.
And are you saying the gray area is just the way that it's categorized, or a specific fact that creates the gray area?
The way I see it, whether or not this is truly an emergent situation could be the gray area that a jury would need to determine. We've had now a half hour or so's worth of debate with the trial judge, and we've been talking and kicking around examples. I think that shows that reasonable minds differ on inferences that can be drawn. Cats and trees versus a situation where somebody's at a scene for a gate open or a dog call. And again, it seems to be a case-by-case basis that needs to be addressed on its facts, not as a matter of law. When you think about routines, as discussed in several of the cases here, what is a routine manner? When you think about it, somebody's doing a routine inspection to avoid the potential of future harm. You're checking electrical boxes to make sure nothing happens in the future. And in this case, the time frame clearly is a little bit different, that you're assuming that the fuse box is not going to have an immediate danger of a fire, but that's exactly why you inspect it. Here, in essence, Sergeant Stevenson was inspecting the scene to determine what needs to be done. He determined no action needed to be done, and that he could wait for animal control to come out. So I think the cases are very similar in the sense of the routine matters. I think we've talked about exigent versus emergency, and I think that's another word for urgent versus emergency, which is the difference between Category 2 and Category 1. One other thing I would point out with my last 30 seconds is somehow the fact that Sergeant Stevenson was trying to unholster his weapon has turned into he drew his gun in an attempt to shoot the dog. The facts that were agreed to in the affidavit, the defense pointed to paragraph 4 in the affidavit, which does not admit
A disclosure statement, though, wasn't it?
Yeah, but again, I think the disclosure statement's exactly that. It's what you have subject to depositions and affidavits that are going to solidify your theories on a matter.
I'm a little confused about that, because
Yeah.
your disclosure statement, yes, you do, and depending on what other evidence you find out, but not what other evidence you found out from your client.
Well, I know we're over time, but just to address your last point, I've seen situations where evidence comes out in a deposition that you weren't contemplating or couldn't have been contemplated in a disclosure statement. So that's why it's static. If this case proceeded with further discovery, I would anticipate the disclosure statement would have been amended to reflect the facts as they were. That's my typical practice.
Do you have anything else to add? I wanted to ask you a question, but
No,
I
Your
don't
Honor.
want to take one. You were already over. Just out of curiosity from the record, I don't know if it has any bearing on it. What happened after the dog attacked Sergeant Stevenson?
Ultimately with the dog or
No,
right
I
after?
understand what happened to Sergeant Stevenson because he was injured, but did they take action against the dog?
My understanding was the dog was put down.
I mean, was he shot there or was he?
No. Your Honor, again.
Later,
The dog was euthanized, is my understanding. It was because you saw in the footnote that it looks like there was a prior instance that we didn't know about, and certainly Sergeant Stevenson didn't know about when he was at the scene. But yeah, I guess that one's to answer the dog lover question. Panel members,
Going outside the record, bad judge.
thank you, Your Honors, for the
you
opportunity to address the court.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course, and at this time, the court stands adjourned.